My name is Lauren Glynn, and I'm an estate planning attorney. Today we're going to talk about the subject of what happens when you die with a will, how does probate work, and how long is estate administration. Now, I am an attorney in New York, so all of this is generated to New York law. You need to know that. If you're outside of New York, you should consult with an attorney in your own location and state. All right, for an estate administration, these are similar steps whether you have a will and have to go through probate or whether you don't have a will and have to go through administration. When you have a will, it's a little bit easier because all the people are already designated. If you don't have a will, then we have to find your family. So, step one, when your executor or your administrator goes to file documents, these are the documents that they're going to need. It can take up to 4 weeks to have the notices properly returned, and in general, filing the petition and supporting documents can take 2 to 3 weeks. If we cannot locate people for your family tree or other, if you have people inside your will that have bequested and we can't find them, it can take longer. Sometimes estates are open for years simply because we can't find everybody that needs to be noticed involved. So the first thing an executor or an administrator is going to do is file the petition and the supporting documents. In New York State, the petition lays out who is the distributee of the estate, people that would inherit if there were no wills, who is named in the will, either as executors, fiduciaries, or beneficiaries. And we have told the court that we are noticing all of them and that the executor is able to step up and willing to serve in that role. In order to do that, they're going to file an oath and designation, basically promising that they're going to do the right things with the assets once they have access to them. We're also going to put in the last will and testament. We need the blue ink original. So copies don't work. If we have to have a copy, then we have to do something called an administration CTA, which is effectively annexing the will to the wishes of the administration. We also have to file a full family tree. This is important. If you're putting together all of your paperwork for your family and you know that you've had siblings that have predeceased you, children that have predeceased you, we have to have that information, either death certificates, prayer cards, something, or an obituary. These days, obituaries are expensive, so fewer people are doing them. Prayer cards will suffice, but we need something inside your file that shows that this person did in fact predecease you, and therefore we don't have to notice them. We're going to need a certified death certificate. That's an original. We're going to need a copy of the funeral bill. The funeral bill does not have to be paid at this point, but we do need to put the court on notice as to who is owed that money. Under law, funeral directors get first crack at an estate. They are the ones that need to be paid because, quite frankly, if we didn't have to pay them, very few people would want to be in that business. We also have to file waivers and consents to the appointment of the executor. So when we go and we notice the entire family listed in the will, as well as everybody that's related that isn't listed, we have to send them waivers and consent forms, basically stating that they understand that they could contest you as an executor, and they are choosing not to do that, and that they are consenting to the appointment. Under law, a contest is limited to the validity of the will. So it could be that they just don't, you could have siblings or you could have family that decides, I just don't really like you. You might be disorganized. You might not be, the smartest of all of us. We might be better educated. There's a lot of reasons that people feel that they should be the executor and not the people that have been appointed. However, the will control unless you can show that the nominated executor is guilty of a felony or crimes of moral turpitude or is otherwise completely unfit. Now, unfit and disorganized are not the same thing. You can have someone that's disorganized and uneducated and still be an executor. Unfit is someone that has proven that they will not tell the truth, that they will lie to the court. So that is something, or if they are also incompetent or incapacitated at the same time as you. So everybody, living family that would inherit if there was no will, and all the beneficiaries who inherit under the will have to agree that the executor is the right person to be appointed. Now, there are also certain circumstances where other information has to be put before the court. If you are the only individual that is in the family tree, so if your family tree looks like a stick and it stops at you, you probably need an affidavit of sole heirship, which means you need someone that knows the family well enough that they would feel comfortable swearing that this is the family tree and it's a stick and it ends with you. So that would be a long-term friend, maybe a relative that's an in-law, someone that isn't blood related. We also, again, we're going to need death certificates, obituaries of any predeceased relatives. And at this point, when we go to file, we have to pay a filing fee. The filing fee is based on the amount of assets we expect to collect. So your attorney is going to estimate inside the petition what the rough value of all of the materials that we're trying to get are, all the assets. So if it's real property, we're probably going to use the assessed or fair market value of the home. If there is assets in the bank, we're going to have to submit how much we think there are. Now, if you estimate incorrectly, let's say you think there's maybe only $5,000 in a bank account, and then you find out that there's $50,000 in a bank account, do not panic. Filing fees can be refunded to you if you overestimate, and you will have to, at the end, if you underestimate, you will have to pay and make up the difference in order to close the court file. So don't panic. All right, this is a lot of paperwork, and a lot of the paperwork can be hastened or made faster if we make sure that in our files we have good contact information for all the family, distributees, family tree, everyone, so that letters can go out on time. Now, if we have an issue and we have a member of the family that says, I'm not signing this, I don't know what it is, and I don't want to participate, so they're refusing to return the waiver and consent, and we need to make sure that we have the ability to move forward, we're going to go forward to step 2. Step 2 is optional. It's called a citation date. So you cannot object to someone being an executor forever, but if you have good cause, you can object. So you would tell the person putting forward the petition, I won't sign the waiver and consent. Then you're going to be served. The court will mail you. It'll be certified mail, and you will be served with notice of a citation. If you're in New York, most of the time, the attendance can be virtual. I am finding out now that some of our local judges are preferring in-person appearances, and so they are putting out that there are no virtual appearances required. But that is a court-to-court issue. So if you are outside of the state and you get served a citation date, which is a nice formal letter that just says you have to be in court on this day to speak your piece, then you either want to appear in person, contact the court clerk, see if you can appear virtually over Teams. If you're required to appear in person, you can appear. You can also hire counsel to appear for you. When you show up, you will have to go and explain to the judge why you do not feel comfortable waiving and consenting to the appointment of the executor. And again, your comfort level is going to be limited by law to certain issues: the validity of the execution of the will, and the actual moral character is demonstrated through the person nominated to be the executor. And again, we're looking at things like actually being convicted of crimes, not, oh, when he was a little kid, he stole my Lego set, kind of thing. In terms of validity of the will, you want to make sure that the will was signed in front of 2 witnesses, that the witnesses have affidavits with them stating that the person was of sound mind, could read and write the English language, understood what they were doing at the time, and acknowledged to the witnesses that this was indeed their last will and testament, and that the content of the will is what they intended on their passing. So if you think for any reason that that will is not valid, either because there was another will executed after this, or if you think that the person wasn't of sound mind, or you think that the witnesses didn't witness it correctly, then you have every right to contest the validity of the will. If you're at the citation date, you're going to tell the judge what the grounds of contest are, and then the judge is either going to order you into discovery, in which you will have to go through a deposition where you depose the witnesses, find out exactly what did happen at that will execution ceremony, or the judge will dismiss your objections because it isn't an objection that can be cured by law or one that is even acceptable. So examples of acceptable are: he was under the influence of drugs and alcohol at the time that he executed this. We know that because these are the diagnoses from his family. They had mental dementia at the time. They didn't have testamentary capacity. Or even I think you have the wrong person. sometimes comes through. So that you can sit down, have a deposition with the witnesses. If the witnesses are no longer alive, which does happen, then their affidavit that they've sworn to before they died is going to be controlling. So you have to have some very compelling outside evidence. Now, there are times when the will predates somebody's bad acts. I saw that the other day, where an executor was nominated, but after her nomination in the will, she did proceed to steal a felony amount of money from her employer. It turns out that the spouse then never redid the will, or if they did redo the will, which they told their children that they were going to do, that copy has not been found. So in that case, that's a very strong argument for a citation and a very strong argument for someone not to be nominated an executor, because at the time of the nomination, they had a clean record, but shortly thereafter, they did not. A judge would be very leery about appointing someone with that moral record. Now, a citation is not a requirement. A citation only happens if distributees and beneficiaries will not sign waivers and consents. Citations can also happen through publication if we can't locate someone, but we know roundabout where they used to live. For example, if you have a client that used to be in a specific neighborhood that had a local paper, we could put in that paper, hey, this is going to happen on this date, show up or forever hold your peace, and that might be sufficient. Usually a citation date takes about 4 to 6 weeks for the probate court to actually put it on their calendar from the date that you request it. So understand that that can be quite a long time to wait. Following the citation, you will get a decree if you are the executor and the objections are overruled or not substantiated. A decree is the actual paper that opens the estate. This is the date that you're going to use for the beginning of your creditor timeline. When the estate is opened, you get your decree. You will also get what are called letters testamentary. Letters testamentary are papers with a little gold seal on the bottom written by the clerk explaining that you yourself as the executor are now in charge of the estate and able to open a bank account, gather assets, and negotiate on behalf of the estate. You as the executor will have to apply for an employer identification number, an EIN. This is something we do for free through the IRS online portal. You will need that to open a bank account. You'll have to have the letters and the decree as well as an EIN, and you can open a bank account to be able to put money into. Once that bank account is open, you're going to start gathering assets. And whether that's listing the house for sale or picking and collecting the bank accounts, talking to the investment advisors, actually putting out the death certificates for the life insurance, those are the things that you are responsible for doing. You're going to gather assets for a long period of time. And one of the things you will also be required to do as the executor is to file tax returns for the estate and for the decedent. Those are two separate people. So the decedent, the person who's passed away, will have a final tax return for the year that they were alive and earned income. So that means if someone was on Social Security and they passed away, you will have to file a tax return for them because they did receive income in that final year as an individual. You may also have to file an income tax return for the estate if the estate accepts more than $600 of income in that calendar year. Those are two separated returns. The estate files underneath the EIN that you are going to be accessing as the executor. The decedent files under their final actual, Social Security number. Now, one of the things you might do, let's say you're getting started and you have no idea where this person had their assets, is to ask the IRS to give you copies of the last 5 years of the decedent's tax returns. Tax returns can be very helpful because they will show you where people were receiving income from. Sometimes individuals get K-1s from investment accounts. Sometimes individuals have work where they have life insurance. All of this stuff, if you really don't know much about the financial picture of the person you've been, chosen to represent, can help you. Also, if you're dealing with a high net worth estate, you know that this person has a lot of money, over $5 million. You're going to want to take a look at their prior year tax returns, not for gossip, but to see if they actually took any gift tax exemptions, life estate gift tax exemptions and things like that, because that's going to be what the accountant that you're going to for their final return in their estate have to work with. So you may want to work with an experienced accountant who does estates, especially high net worth, and help them figure out exactly exactly what you'll need to move forward. Most importantly, in New York, you have to take a deep breath at this point because a creditor deadline will have to pass before you can actually give away any of the money and close the estate. In New York, the creditor deadline is 7 months, and that is from the date the executor is appointed and the decree is issued. So it's not from the date that you filed. It's not from the date of death of the decedent. It's from the date that the court has actually said you are in charge of the estate. 7 months have to elapse to give a creditor a chance to step forward. Now, if you distribute assets, let's say you get in charge and you find out that there's a bank account with $20,000 in it, there's real estate, and you decide that you're going to give the bank account out to the children because they need money right now, and then you put the real estate up for sale. If you flash forward in 4 months and it turns out that your decedent owes more money in medical bills that occurred during their death, or mortgage. You didn't know that they had both a HELOC and a mortgage and they were underwater on the balance of that house. And there's a difference in what is owed, and you've already given away the only free cash in the estate. You yourself will be liable, and you yourself will have to pay the money back. So don't give away money early. You need to wait until all of the bills come through. Now, you might think that that's silly, or you might think that there were no bills. Again, people have interesting financial lives. Do not presume that you know the full picture unless you were, their power of attorney and on all of their accounts, and maybe you did know their full picture. If you're just stepping in and these were your parents, it was an untimely passing, you're going to want to make sure that they weren't underwater. You're going to want to make sure that all of the bills can be paid, especially the funeral bill and especially the attorney's bills by the time you get to the end. So what we do in our practice is we wait for about 5 months. We try to spend the first 5 months collecting, getting all of the mail, picking up all of the actual bank accounts, getting the cash together, selling the assets. The only time I approve bill pay during this period is if it is needed to sustain an asset. So we'll have to pay the heat bill if we're in upstate New York and it's February. Otherwise, the house could be at risk. We have to pay the insurance bill. That's something that you have to do so that the house is not at risk. But do you have to pay the funeral bill? There's a 1% late fee if you don't. Every month there's some incredible, there's interest charges. So let's think about that. But what about credit cards? The credit card bill has come in. We're not going to pay that. There's no interest that will accrue after a person's passing. We're going to put that one to the side, and we're going to wait till we get to the end of the estate and we know statutorily who gets paid. That's another issue, is that if you believe the estate is insolvent, understand that there is an actual statutory order in who gets paid and how much. So the first person legally that is going to get paid from this estate is the attorney. The second person is the funeral home. Those two, and generally attorneys, will actually take a back seat to a funeral director getting paid because of the interest accrued, and attorneys don't accrue as much interest on their bills. But those are the two professionals that if you don't pay them, they're not going to help you and you're in trouble. So save enough money to make sure that you can honor those obligations. Things like unsecured debt, that goes to the bottom of the list. That's something that if we don't have enough money, those credit cards will be able to go write that off at the end of the year. They may not get paid. Now, if there are more debts than there are assets, you're going to have to let all the family and the distributees know it doesn't really matter what's in the will. There's nothing to give you after we sell it. I don't envy executors in that position. It is a very difficult position to be in. But what's worse is if an executor gives the money away early to the kids because they need it, they demand it, they want it, and then we find out later that our decedent was legitimately hiding a double life and had more bills than they could afford, and then you end up having to pay them back. Now, bond comes into play here. Generally, when we write our wills, we say that an executor can serve without bond. That's convenience for executors, meaning they don't have to post an insurance bond requiring them to have an asset allocation in the amount of what they could misuse. Now, you could be required to post a bond by a court, especially if you have a negative history, you have a bankruptcy on your record and you're going to be an executor. Maybe you've got issues with, criminal, not full criminal activity, but maybe you've had violations before. The court can require you to file a bond. The bond acts as insurance that if you do steal money in a contest, that the bond will pay on your behalf. All right. After we get through this 7-month period, we're here in 5 months, the next thing you're going to do is an accounting. So the accounting is going to put together, and this can be informal. I have it here. The best practice is that an executor puts together an informal accounting, and it shows beneficiaries all the monies collected, every asset we've collected, all the expenses. So everything we've had to pay to date, things like the funeral, things like the attorney's fees, things like, any of the bills for keeping the house running while we've been waiting. And then it'll have assets left over with proposed payments and distributions. It's very simple. You can do this in an Excel sheet. You want to make sure you put together that informal accounting with all the proposed distributions to the kids, and you're going to show it to the beneficiaries. And you're going to say to the beneficiaries, if you agree with this accounting, I want you to sign this release of claim, and I want you to sign these receipts and releases. Now, if there are debts, you have to have the claim settled. So that's going to be something that is a proposed payment, so the claim will be settled. You have that in there. We're going to pay off the car at this amount of money. We're going to pay off the credit card at this amount of money, so that the beneficiaries understand where the distribution is going, and that's why they can't pocket all the cash themselves. We're going to owe this amount in additional court fees because we underestimated. That type of information is all included in this accounting. You give the accounting to your siblings or whoever else the beneficiaries are. Beneficiaries are going to either agree or they're going to ask questions. It's better that they ask questions now so that you can work on the accounting and talk to them about it than before you give away all the money and then they come back and say, what's going on, right? So we want to make sure that we get the receipts and releases in hand first. That's another game of chicken you might be playing. When you say to somebody, look, this is your proposed distribution, this is the accounting, this is the receipt and release that you're going to sign that says you've received this amount of money. And then once I get that in my hand, and you're going to have to sign that in front of a notary, when I get that in my hand, then I'm going to hand you the check. I will tell you, sometimes it turns into a game of chicken where people argue that they are not going to sign the receipt and release until the check is in their hands. But I promise you, if you release the funds and you give them the money before you get that receipt and release back in your hand, it ain't coming. So make sure you hold firm. They want the money, they sign the paper. And even if you want to do hey, we're going to literally sit at the table together and I'm going to have you sign this receipt while I slide the check to you, sometimes that works for people to be comfortable. But you do need that receipt and release. If you do not have it, you cannot close the estate, and you're opening yourself up to a lot of problems. That beneficiary can then turn around and argue they never received the money, especially if you gave them a physical asset. Let's say that they were entitled to a piece of jewelry or they were entitled to a specific dish. You need to get on paper that they did receive it if it's in the will. And if they didn't get it and it wasn't there, or you handed them the ring and they didn't give you a receipt and release, they can turn around and tell the judge that that transaction never happened and they never received that asset. So that's something that you can get in a lot of trouble for if you don't absolutely demand it. Now, this process at distributing assets, we usually start looking at it about 5 months in. We don't do it until that exact 7-month deadline goes by. As soon as that 7-month deadline goes by, we try to get everything prepared up until advance. As soon as that date passes, we're going to do this as quickly as possible. We're going to send out all of the receipts. That's why we want to make sure we're prepped and ready. Get all of it in so that as soon as that's done, I can close the final paperwork and close out the estate. Now, we want to do that so that the creditor timeline isn't forever. You don't want to have an estate open for 30 years. There could be people that come in and try to sue it, and they could get more claims. You want to limit that exposure and liability. So the next step, the final step, is you have to file the final paperwork with the court. Believe it or not, this is the step that a majority of people forget. They just simply don't file the final paperwork. They distribute all the money, they don't get receipts and releases, and then they don't put in any of the final work, and so these estates are just open for years at a time. Now, If you go to file the final paperwork, beneficiaries can object if they disagree with some of your actions and decisions. They can also request the court order a formal account proceeding. What that means is, let's say, as the executor, you had to make some tough calls. There were 3 or 4 rental houses in the portfolio, and you needed to sell one to be able to cash flow some of the expenses and then give the other 3 to the kids, but there were kids that didn't want the one that you chose to sell. Those types of things, those discretionary decisions and actions that you've made, they can contest that if you've done that and that has injured the estate in any way. It's a challenge to do. It is a full court proceeding. It is a full trial, but it is something that does happen. And we see it a lot when we have siblings that are not on the same page. So when we have assets that are discretionary, usually when we don't have enough cash flow for the estate, then we have to sell some assets. And it could be that we're selling assets that were actually gifted to kids. And hey, if I don't have the money to settle the debts, I got to settle the debts before you get the house. That's the truth. So I've seen a lot of contests on discussions and discretionary decisions like that. That is something that is a nightmare. We want to try to head that off at the pass, which is, again, why we start doing all of the proposal work back here in the beginning. That being said, once the objections are closed, the formal accounting is accepted by the court, you still have a few more sheets of paper to file. You have to promise that you did indeed file all of the tax returns, that there are no federal estate taxes due against the properties or against the persons. And you do have to swear that you have distributed all the assets to the best of your ability. You also have to file what's known as an inventory. If there are firearms in the estate, you have to file a firearms inventory explaining what firearm is, where it went and what happened to it. These are documents that are fairly simple to fill out. There's easy forms online that you can get from the public that the court has put out. But these inventories have to be filed with the court, and you have 15 months from start to finish to file your first inventory. If you do not file your first inventory within 15 months, the court can revoke your letters because you are clearly not living up to the position if you can't get these things in. Now, I will tell you that I've had a lot of estates where people just simply forget. They don't do it. It takes 1,000 years, and then it's just open forever. Eventually, the court will just close the file, but you are still on the hook if anyone comes to sue you because you haven't done the correct thing in closing the account. Now, the total time frame. If you are on the ball and you have every information you need in the file ready to rock and roll, you've got your divorce decrees, you've got your death certificates, you've got your family trees all put out, and everyone knows what's going on with it, it can take as short as 9 months. However, most of the time, we're not always on the ball. We've got to get connections back and forth. It does take time for things to be mailed. So it usually takes at least 1 year to complete an estate. Sometimes it can take even longer. I've had clients that have owned trusts that have mortgage notes, that they're lenders to people and they hold notes. And that note can be in effect for up to 20 years. I've had estates open that long. It's kind of wild. So I hope this gives you a good overview of what to expect in New York when you're filing for probate. This is also an administration timeline. So if you do not have a will and you die, this is the same process your administrator will go through, except in the beginning, we will not have an original last will and testament. All right, my name is Lauren Glynn. I am an attorney here in Upstate New York. My goal is to help people leave legacies that they are proud of. If you have any other questions, feel free to reach out to us. Please hit the follow or the like button so that we can continue making content that can help you in your journeys. Have a good afternoon.